So, Marie, it's great to see you again now, since we're meeting for the Ius Laboris Privacy Group meeting. Great to have a chat with you. Can you tell me what is going on in data privacy in Luxembourg at the moment?
Well, in our work-related practice, what we see is a lot of complaints from employees in relation to data subject access requests, but also about employee monitoring. So that's both hot topics in our daily practice.
Okay, that's good. That's similar in Germany, apart, of course, from AI, as we discussed before, which is not going to be our topic today. Can you tell me a bit more about the categories of monitoring that you're seeing under use in Luxembourg?
So mostly we have CCTV, of course, which is the most spread way of employee monitoring in the workplace. But of course, main concern is about monitoring of employees' emails. That comes a lot in the complaint that we receive on what we have to support our clients on, and of course, geolocation of company cars.
Okay, yeah, we have those all as well. Regarding the monitoring of emails, what would be a typical case? Would you need a reason for an employer to even go into emails?
Yeah, so first of all, what needs to be outlined first is that employee monitoring is specifically regulated under the Luxembourg Labor Code. So we have a bunch of specific provisions that needs to be complied with when it comes to employee monitoring in general. So before implementing such monitoring system, employers have to follow a set of processes, including specific information to staff delegation and potentially a prior compliance opinion from the DPA. But when there is a suspicion of wrongdoing, specifically in this case, employer tend to go through employee email and check to collect potential evidence of breach of contract. So in many cases, we step in when the employer needs to search for the employee email.
Yeah, that's similar in Germany. And in Germany, it makes a huge, by the way, we do not have specific legislation at the moment addressing the review of emails. It does make a huge difference under German law if private use of the email is allowed or not. Is that an aspect under Luxembourg law?
Well, not really, in the sense that the principle is that business employee systems are professional, are deemed to be professional. Now, even if there is a restriction on private use and the employee use it for private purposes, you cannot access private emails. That's something that cannot be,
of course.
Yeah.
But you would still be able to look into the business email if let's say, private use had been tolerated in a moderate extent, you would still be able to. That's interesting, because in Germany, that's a distinction that makes it more difficult for a variety of reasons, because you may be stumbling upon private things still.
Okay. And is there any specific challenges that you have when advising clients on employee monitoring? I mean, what's a recurring topic that you have to advise on?
It really depends on the industry sector the client is in. I would say, like, for example, in retail, CCTV is, of course, a big topic. They work a lot with CCTV to prevent theft. And there's, of course, a lot of case law to what extent that evidence can be used, let's say, in cases of where thefts have occurred. Can you use that as a means of evidence? Also in retail sector, you have RFID chips. I don't know if you've heard about that. It's in garments. It's that small chip. And of course, it you can trace a lot of information with that, like how quickly is somebody restocking the garments in the storage and all of that. So that's also interesting because it can be used for monitoring. GPS tracking is fairly limited under German case law. It can only be used for, let's say, you have a pool of vehicles for a hospital or for the municipal garbage collection or so, where you really need this to be able to organize, or for buses, of course. And then you can use it, but you wouldn't be able to use it just because it's the company car. So.
Yes, of course. Purpose is something which is the DPA in Luxembourg is really puts really a great attention on, because we had a case where an employer was sanctioned for misusing data collected through video surveillance. That was the purpose. The initial purpose was for health and security and crime prevention, but the employer used those data in order to evidence wrongdoing from an employee who repeatedly came late at work. And, the DPA found that this was an excessive misuse of the employee data, which is quite interesting because on the opposite, labor courts seems to be more tolerant when it comes to, using surveillance data to sanction an employee, to discipline an employee. So that's something. Is that something that
you often have that slightly differing view between the data protection authorities, and in Germany, you have one for each German state. We have federalism, so that makes it even more multi-layered. But the labor courts tend to sometimes have a different view on to what extent it can be used as evidence, and in principle, even if there's a slight, as we said, breach of the data privacy rules, that doesn't rule it out as evidence in the labor court, or not as strictly as the employee side would sometimes like to see. And also, we have that interesting question. You're looking at subject, you have the purpose of looking for topic A, let's say theft, and then you end up finding something totally unrelated, like he's being late every day at work, so it's topic B. We call that Beifang, like in fishing, where you're fishing for one category of fish and you end up fishing coming in with a different category of fishes on top of that. So we have similar topics, it seems. Moving to DSARs in Germany, this is really, we just heard in Ireland, it comes up with when the Irish colleague was giving a report on her country, she was saying it comes up with literally every case they have. I wouldn't go quite as far, but I would say in Germany it's maybe a third of employment termination cases, and most litigation in Germany, individual litigation, is about termination. And I would say a third of the plaintiff counsels send along a DSAR request, which makes it more labor intensive. How about Luxembourg?
I think it's the same. Since 2018, we've seen an increase of DSARs in employment litigation, and it has definitely been weaponized by employees trying, even during negotiation of settlement agreement, they're putting employers under pressure to get a deal more quickly. But definitely, DSARs is also one of our main concern when we are advising clients on work-related privacy issues. But we had an interesting case, not work-related, but it was issued by a commercial tribunal, which dismissed shareholders' request of access because they considered that the purpose of the shareholder was really to make a kind of fishing expedition, which is not the primary purpose of the DSAR, which is interesting because it conflicts with the European Data Protection Board.
Exactly.
Guidance.
They say, regardless of the purpose, you can ask for it. And so I'm quite curious to see if that could be overturned by the Court of Appeal. So that is the first instance judgment, but this definitely draw my attention because that's the first time that I see in a judgment that the DSAR cannot be used for another purpose than Yeah, there used to be like single cases in that direction, but at least the EU guidance is pretty clear. It's your right, you can ask for it regardless of your hidden purposes. So that's probably not something we would go for a long way with when advising an employer. What our clients struggle most is to what extent do we need to provide copies? Because otherwise you have a template where you list down the answers that need to be given. Of course, you need that list of recipients now after the 2024 case law, or is it 2023 already? Those Austrian cases?
So,
was 23, I think. But so the list of recipients, they have it in store once they had their first DSAR. But the copies, this is really a bit of a headache topic. How do you deal with it?
This is the main concern that we have, because in most cases, these are employees with a long-led service. So what we do is we also always advise employers to do their best to have to provide documents, but we see more and more that employees are getting specific into which kind of documents or data that they want to have. So in this case, it's better, it's easier to handle, because we can, pick those documents and assess whether it is relevant under GDPR to provide a copy. But in many cases, we have to, delete all irrelevant information that doesn't
this is then the editing, which takes a lot of time. And so it, of course, helps if they narrow the request. We had one case where we asked the data subject to please narrow, and we have thought, we had 10 topics, and we said, can you please say these topics are okay? So we are going to narrow our search because we cannot provide 100,000 documents. And he came back with he said, well, great that you ask. I have these 30 topics I want to be informed about. So that was not really a helpful answer. And then, of course, it's always a question of discretion. To what extent can you say no? Can you say yes? Do you need to comply? Yeah. Also, of course, it helps if you have strict retention periods in place. If they are short, that really helps. If you really implement, we have one client who has 6-month retention for emails. This is extremely helpful because emails are the most messy to extract copies from, because they are unstructured. They have all kinds of sensitive data between work-related information. My child is sick, I need to work from home, etc. What is the Luxembourg situation on the exemptions of when you are protected, when you need and can blacken out information because it touches third-party rights? Is there any legislation on that?
No, we do not have specific legislation on that. So we basically rely on the guidance from the European Data Protection Board and the authority. But basically, this is, the same that we have to assess based on the balance of interest between the controller and the data subject. But we refer to the basically regulation.
That's same in Germany.
Yeah.
So thank you, Marie. It was great talking to you.
Yeah, thank you, Jessica.
Yeah.
Very interesting.
Great. Thanks.
Thank you.